Hello, everybody. Hello. Thank you for that. I want to thank also the Office of the Dean. I want to thank the Division of Equity and Inclusion. I especially want to thank Jennifer Geller because she has been shepherding me since September with this talk. Can you please give me my abstract? You're taking too long, but she's lovely. And I want to thank Lillian Lorenzen for doing a lot of print jobs for me as I finalized the talk tonight. But I really, really want to thank the students who I met with this afternoon. You all have my heart, but you don't have all my heart. I want to thank my folks in Carlisle, Pennsylvania at Penn State Dickinson Law. They're having a watch party. For this, so please, give them a hand and let them know. Yeah. What law school has a watch party for their dean? Oh my God! And I had to call them on the phone. I'm like, I'm here. So it was just great to have them with me, and you can tell how much I love them by virtue of my saying so right here on live streaming. I also want to thank my friend, my dear sister, Marcelyn Burke. She believes in me to give this lecture. The lecture where Derrick Bell's name is attached to it. That shows you the level of love and loyalty and commitment that we have in the decanal ranks. And I just want you to know that your dean is a leader in those decanal ranks, making opportunities for people like me and others to be spotlighted for the work we're doing. And that's part of the coalition, right? So thank you, Dean Burke, for allowing me to be here. So I'm gonna get started with this talk. I can't promise you I won't cry. So I'm just going to say that right here. And if I do and you feel compelled, you can come up and hug me. Thank you for that. I'm also about being completely authentic and straightforward. And so this may start very differently than lectures you have heard. I admit that I'm a relative latecomer to Derrick Bell's teaching and learning, his prose and scholarship, even his administrative leadership and influence. One of the reasons for that is because I attended a historically Black college and university. So we did not really have a need to study critical race theory because we were living critical race theory. But that said, there's always something to learn. So this late start of mine could easily have been called a deficiency in my legal education. But I passed that off as not too relevant. As I mentioned, we were living the firsthand experience of law students who, in many cases, were other. But that being said, there's something important about understanding the dynamism that comes from being a Black lawyer in America from whichever entry point you take. So even being a latecomer, Derrick Bell's unique expression of critical pedagogy within legal education has allowed me the space and the time to develop my own unique experiences as a Black woman in the legal profession and the legal academy, providing me a unique way to connect my own experiences and ways of knowing, like Derrick Bell did. And I want to tell you a little bit about Derrick Bell. Don and Laura, you will have patience with me. Derrick Bell was educated outside of what we term elite law schools. I'd actually like to repeat that. He was educated outside of what we term elite law schools. He was a product of Pittsburgh Public Schools. He received his bachelor's degree from Duquesne University. He was an Air Force ROTC cadet and was commissioned as a lieutenant in the United States Air Force. By his own account, he was sheltered from direct exposure to bigoted, individual racism by hardworking, blue-collar Black parents who actually themselves experienced firsthand the sting and the trauma of both structural and individual racism. Despite this early sheltering, Bell was ushered into the reality of the dominant white patriarchy after traveling to his first duty station in South Carolina. During this time, he saw racial default rules regulate where Black people could physically be. That's perfect, like GPS. Where can Black people really be? And she's like finding out where right now. And that's your dean. And what jobs they would be allowed to do, and how they would be allowed to live. And I want us to really pause on that, to think about the regulation of your person. When we learn in torts about inalienability, that's like my favorite word, and how that word contradicts being regulated about where you can go, what you can do, who you can be with, and what work you will be able to attract. After service during the Korean War, Bell went on to earn a law degree from the University of Pittsburgh School of Law, graduating fourth in an otherwise all-white class in 1957. But he was unable to secure employment. Now, raise your hand if you're my first, second, or third graduate in this class. If you raised your hand and identified yourself, you would be telling me where you'd be clerking right now. That's what you would be telling me. With assistance from law faculty who recognized the hypocrisy of an honor graduate and veteran not receiving employment looks, Bell eventually secured a position at the Department of Justice. He worked in what was called the Health Education Welfare Agency. He later transitioned to a non-lawyer position. Think about this, I'm talking about 1957. A non-lawyer position as executive director of the Pittsburgh branch of the NAACP. And it was only then when he got his second look from Thurgood Marshall to join the NAACP Legal Defense Fund in New York. After 5 years at LDF, Bell returned to DC and worked in the Johnson administration. And he was part of the team to desegregate schools by threatening to cut off federal assistance unless they complied with court orders. Although an expert in litigating civil rights cases, Bell was only marginally successful in his initial courting of the law teaching market. Now you would think this giant would be courted extensively. No. He had to actually take an executive position at USC, not an executive position, an executive director position, at a poverty law clinic, and only was able to attract an adjunct faculty position that would allow him to teach. His stint at the poverty law clinic building that network in the legal academy, came together in confluence with the assassination of Dr. Martin Luther King Jr. and with the ensuing riots. All of this converged to then convince some of those schools we term elite to consider him for employment. Why? Because maybe if we bring a Black person to the faculty, we will look progressive. I recount Derrick Bell's experiences because, among others, it lifts the facade. It uncovers the first myth that we should be thinking and talking about, the myth of the neutrality and objectivity of merit. A system in which we mask who gets what by calling systemic racial inequality merit, where there are embedded material advantages for some and equal and disparate disadvantage for others. This is persistent racial hierarchy, driven by mythological ideologies about ascriptive discrimination, traits we can do nothing about. Like there's no lottery system before you come out the womb. I want this, this, and this. I'll be okay if I got that. That doesn't happen. We get what we get. So wouldn't it be great to be in a place where you get what you get is met with love and not hierarchy? Okay, yeah, come on now. Make me feel good. I like it. Derrick Bell saw these systems at work in his career as a civil rights litigator and also in his second career as an educator. Both of these experiences allowed him to theorize, lift out of the anecdotal into theory and intellectual discourse, conversations about race, power, and how they combine with law, how they then constitute, once put together, patterns and structures of inequality. This is what our nation has been platformed on. Derrick Bell's thesis of the permanence of racism and his theory of interest convergence are often viewed through a lens of pessimism and linearity. So as I recount his story, we may feel a sense of despair, but I reject despair. I've chosen to read Professor Derrick Bell's thesis and theory more like a challenge. And if anybody knows me, I am very competitive. I will strip you at Monopoly, Pinochle, Jenga. You will have no chance. I beat my son, and he's 11. At Jenga. Exactly. And he'll tell you the truth. He'll be like, that's my mommy. But it's a challenge to ideate, to prototype, to test solutions for a more just and equal multiracial American democracy that will tap into what truly is law's emancipatory power. So I came to Eugene, Oregon, via Las Vegas. And when I was in Vegas, I felt like I was transported right back to Derrick Bell's work, Faces at the Bottom of the Well. He talked in this book about being in a black sedan car ride with Jesse B. Simple. Well, I felt like Bell was defying temporal mechanics to join me in Vegas, because I had a ride with Abdul, the Ethiopian Uber driver, this weekend. And I couldn't get my foot into the car before Abdul posed a question to me. He didn't know me. He knew what was on the app. Danielle. Okay, yes. I thought he was calling my name because it was, my Uber. When will this stop happening? I realized instantaneously that his was not a question posed to me really to answer, nor was it a rhetorical question to move his conversation along. Instead, it was a visceral question. He saw a black woman, and he had to engage. It wasn't stream of consciousness. It wasn't philosophical. It was an attempt at connection. Like Bell with Simple, I spent the ride nodding affirmatively to everything he said, not needing to critique or to question his pronouncements or his assertions. His commentary was heartfelt and passionate, but it was nothing I had not thought or heard in that ride or in any other ride. What caught me off guard, though, was Abdul's path to explaining to me, because he really was teaching me, that people in African countries were kidnapped by slavers and stolen from their communities, homes, and families. And he felt that kidnapping, but still that ability to survive and even thrive, made these individuals some of the strongest people in the African diaspora. Those were his words. Abdul poignantly recounted that those who were kidnapped were ripped from their mothers, never to meet her or their gaze again. And that's when I knew that's why he was talking with me about that. He had to say that to me. He continued to explain that black mothers have been victimized then and now by the taking and the torturing of their children. His proof was in the recounting of the recorded beating of Tyree Nichols, the mob-style beating resulting in Tyree Nichols being killed at the hands of police impunity. This is what Abdul wanted to talk about in that car ride. He hit all the major points in questioning the absence of humanity in the latest killing. He acknowledged that the 5 police officers who tortured Tyree Nichols were themselves black men, and he articulated that this was germane in the sense that they too, while belonging to the oppressed ranks, sought to align themselves with the oppressor instead of seeking liberation through humanizing action. And there was only dehumanization in that exchange that evening. There were more people there, and they too aligned with the oppressor. I heard all of this and more in that 17-minute ride from my friend's home to my destination. And you know it's 17 because it's the GPS, right? I could not help but connect that almost one-way conversation with Derrick Bell's fictional encounter with Jesse B. Simple in Faces at the Bottom of the Well and my encounter with Abdul. The circumstances are almost too numerous to recount regarding Bell's black sedan ride with Jesse B. Simple and my Uber ride, both occurring on the heels of what we are to celebrate now, Black History Month, both involving working class black people driving academics, and both academics being educated by their driving companions about race, racism, and responses to the problems of our people. So if an Uber driver can teach us about race, racism, and law, guess what, everybody? We can engage in the co-creation of knowledge about it too. We have the tools. The question is, do we have the will? While the subject of the killing of Tyree Nichols by police impunity filled me with indignation, I cannot help but be simultaneously held up and uplifted by Abdul's community expertise, his willingness to acknowledge systemic racial inequality, his acumen in engaging the teaching and learning with a relatively unknown passenger. He didn't know where I fell on the spectrum, but he talked anyway. And his myriad examples of how he has taken action to intervene as an Uber driver to disrupt racism and oppression, parking his car where he sees police in relation to other black people and making sure he bears witness. Do I worry about Abdul? Yes, I worry about Abdul. But am I pleased about the teaching and learning that occurred during that ride? Absolutely. Do I want him to try to interrupt and disrupt police impunity? Absolutely. I want him to do that. In essence, do I want him to engage in the humanization process? Yes. Abdul's community expertise, his theorizing, coupled with his interventionist actions to be of and with the oppressed, and to act to change the world to be of and with the world, affirms my choice to view Derrick Bell's thesis and theory as a challenge to empathize, define, ideate, prototype, test, and get feedback on solutions for a more just and equal multiracial American democracy. He's from Ethiopia, and he's doing what we must do. To be engaged in the humanization process is to develop a theory of being and to practice that theory with others who are committed to the co-creation of justice. I acknowledge that law is a constitutive element of constructing race, and it shapes and is shaped by structures that perpetuate racial domination. But if we are to co-create for one another in pursuit of the love that flows from seeking justice as a function of this humanization process, then we must also acknowledge law's emancipatory and liberatory power. So where does that power reside? Right? That's the question. My response to Bell's challenge regarding the permanence of racism lies in the unfinished work of the 14th Amendment and the Reconstruction Amendments. It is the 14th Amendment in which I locate the blueprint for constitutionally mandated anti-racism. There'll be a test on this, So I want you to be able to say this. I'll repeat that. It's the 14th Amendment in which I locate the blueprint for constitutionally mandated anti-racism. Abolitionists, radical Republicans, and the Reconstruction Congress knew the ratification of the 13th and 14th Amendments were directed to grant formerly enslaved Black people equality before the law. They knew it required protection in their life and in their person, and the opportunity to live, work, and move about the country. They also knew these constitutional mandates had to be supported by comprehensive civil rights legislation, including the Freedmen's Bureau Bill and the Civil Rights Act of 1866. So now we're talking like webs, network of laws. Furthermore, they knew that the abolitionist movement was a critical feature of the spectrum of events leading to a protracted civil war. So we've got legislation, right? We've got abolitionism, and we've got movement, protests, all coming together. These debates and protests, this violence, this war, these negotiations, these compromises, and the politics inescapably centered on the slavery question, which directly dealt with race, racism, and white supremacy. So when you know that, and I know if I asked you all, you'd all say, yep, I know that. Maybe not all of it, but you know that. I mean, before I even finish the next few pages of this talk, you must ask yourself, why do we read the 14th Amendment the way that we do? You gotta ask yourself that. The 13th Amendment and the 14th Amendment must be interpreted against its historical context, making subsequent acts by legislators, lawyers, and judges to read out race consciousness morally, intellectually, and legally bankrupt. The promise of a multiracial democracy compels picking up the baton of anti-racism embedded in those Reconstruction Amendments, while simultaneously heeding Bell's counsel to engage the struggle to embed anti-racism into our structures, our norms, our laws, our customs, and now, most recently, our AI. Can I get an amen? Amen? There we go. The 14th Amendment requires unapologetic, perpetual, and genealogical engagement. Knowing that there is a genealogy to this humanizing work provides inspiration for collectivism and coalition to contest the permanence of racism. What do all of that alliterative stuff mean? Collectivism, coalition, contestation. It all boils down to working together, right? And just as law shapes and is shaped by racial power, reproducing itself through systems, so too can we use systems designed to implement constitutionally and genealogically mandated anti-racism. Now, when I say this word genealogically, I mean we have a connection, a real connection to the people who came before us. We have a duty and an obligation to them. What were they protesting and fighting for? And at the same time, their connection to us centers our connection to those who follow us. That is genealogy. Those are the obligations we owe. So a starting point for engaging with anti-racism unapologetically is to contest the operation of systemic racial default rules. These default rules that just happen to come into being. Why? Because we're so used to repeating them. They are routinized and normalized in our society. And they create false dichotomies that we do not need to adhere to. False dichotomies pervade any discussion of race in America. Any discussion. For example, discussions about race and racism often extend beyond beliefs, intentions, or hatred. Without pushing through this first layer of inquiry, it is difficult to understand the more subtle forms of racism that permit default rules to operate seamlessly in society through structural and institutional mediums. American racial default rules distract us by masking distinctions between the violence of individual racism and the oppressiveness of white supremacy. As well, racial hierarchy uses individual racism to obfuscate a true understanding of the power and domination and control that is at play in the system, the outcome of which is the elevation of whiteness. Uncritical and ahistorical interpretations of the 14th Amendment, to include color blindness and that kind of checkbox diversity or performative diversity, betray the Reconstruction Congresses and their constituencies' purposes and intentions in bringing forth a reformation of American values through constitutional, legislative, and political principles that centered a broad view of race consciousness, expansive enough to address not only the struggle to dismantle racism, but also capable of producing a blueprint to protect against sexism, ableism, xenophobia, classism, homophobia, and other forms of oppression. Yet white supremacy's application of racial default rules, they have made the very engagement with anti-racism controversial then and now. For many Americans, lack of knowledge about the history of Black people in this country, about the history of indigenous or Native peoples in this country, about the history of women in this country, colonizes their views about the meaning of anti-racism. The operation of the racial default rules leads people to consider anti-racism to be divisive, as if it's a mirror of racism, and then we put reverse racism, which is a fiction, underneath anti-racism, and then we call it woke, and no wonder why people are confused. The Reconstruction Amendments fundamentally changed the constitutional order in America, and for that, we should be most proud. They created the world's first biracial democracy. Crucially, they enhanced the power of the federal government by placing the authority to define the rights of citizens in the federal sphere. Had this power been fully operationalized, the Reconstruction Amendments might have ushered in something absolutely revolutionary, a permanent change to the status of Black people, from enslaved to voting citizens. Like, that's well nigh miraculous, had that happen. Those who could participate fully in American society, socially, politically, civically, economically. Yet blunted by white backlash and waning political will, the Reconstruction Amendments were neutered, leaving Black people to contest then and now a liminal existence. And it is that liminality that is the Tyree Nichols situation. That liminality is the George Floyd situation. That liminality is the fear that I feel when my son goes out to school every single morning. because I have to deal with the potential that he's not coming back. That's insanity. And they want me to run a law school? But I do. People in the live stream. This liminality makes situating the Reconstruction Amendments within their proper context a difficult yet necessary exercise. To address the emancipatory, liberatory, and race-conscious purposes of the 14th Amendment that explicitly centered on protecting the freedom, citizenship, suffrage, and equality owed to formerly enslaved Black people, and to enforce these protections as against individuals, governments, and institutions that would seek to impose racialized violence and oppression against this new citizen cohort. It is vital to center the study of race and its relationship with law as both tool and constitutive element shaping and being shaped by the hegemonic power platforming the dominant white patriarchy. Don't worry, I'm coming to the end. Y'all be okay. My prior comments have located anti-oppression generally and anti-racism specifically in the 14th Amendment. In this way, anti-racism functions as a constitutive element of anti-oppression. With this location in the Reconstruction Amendments, anti-racism and its implementation expressly signal why law schools and the legal profession must lead this work. From the inhumanity of genocide, slavery, and subordination to the injustices of Jim Crow, racism, sexism, the law must account for its role in shaping and being shaped by the history of slavery and the exercise of racial power. The integrity to face and acknowledge the complicity of law in the design of systems of oppression is the first element of defining anti-racism. Next, acquiring knowledge about the American system of laws through the teaching and learning of the impact of slavery and systemic racial inequality in the founding document and the Reconstruction Amendments of the Second Founding is the next element for defining anti-racism. Only through such knowledge dissemination will there be opportunities to design equity-focused systems for structuring the multiracial democracy that was the promise of the 14th Amendment and that each and every one of us deserves. This dismantling and restructuring call on law schools and the legal profession to investigate, to analyze, interrogate existing structures while humanizing, ideating, and prototyping new designs for law and legal architecture. The final element of the definition for anti-racism is for law schools and the legal profession to act on this knowledge. How do you act? You act by teaching and learning a context-driven approach that draws on critical pedagogy to co-create and co-curate theory and practice that is both inclusive and iterative. What does that all mean? Change how we teach. That's all that means. And I had a session with the faculty and the staff, so they're on the plan. The origins of institutionalized legal education provide a window into why law schools have a duty to engage anti-racism unapologetically. I want to give you some advertisements from law schools during the antebellum and Reconstruction period. One law school in Georgia, which will remain unnamed, advertised as follows. A legal education would be of great benefit to the large number of young men who intend to devote themselves to the honorable employment of cultivating the slave plantations they inherit from their fathers. To them, a knowledge of the general principles of law are of inestimable value. Another advertisement expressed that many young gentlemen whose parents were planters, right, that's a euphemism, and men of large means attended the school in order to make themselves more accomplished citizens. You are an accomplished citizen when you enslave others without intending to follow the legal profession as a business. So I don't really intend to be a lawyer. I just need to know the system to maintain the status quo. These examples demonstrate that legal education as a formal institution has performed exactly how it was designed over 150 years ago. Law and legal education were established for rich white men by white men. Lawyers in America had and continue to have significant prominence because of the absence of a formal aristocracy. So our lawyers are our new aristocrats in America. As part of the backlash to a multiracial democracy promised by the Reconstruction Amendments, institutionalized legal education worked alongside the courts, state legislatures, to retrench in America slavery by another name. The insidious aspects of elitism, exclusion, anti-competitiveness, and inaccessibility served and continues to serve as a threat to progress in the development of equity-based innovations in legal education and the legal profession. For those who argue that was then and this is now, I posit that white supremacy transforms itself. We have been deluged by a sustained assault from the ideological right on the basic conduct of teaching and learning history through historical scholarship, no less, and translation of equity-minded critical inquiry. While American institutions of higher learning have struggled to find a clear voice and footing in the debate, who's on the front lines? Public K through 12 institutions, libraries. They are the ones engaging critical pedagogy and absorbing the brunt of gag orders and book bans targeting honest and authentic readings of America's racial past. One must ask, where are the lawyers? Where are the law schools? Where is the legal academy? Colleges and universities, looking at Florida, they know the fight is at their doorstep. Today, Governor DeSantis proposing legislation to eliminate, air quotes, DEI bureaucracies. Wow. That is code for erase me. Book bans, insurrection, and illegitimate use of law have at their core the intention to promote ahistoricism, whitewashing of the process and progress toward humanization of all people. There are iterative themes of the use of law and the use of time as either tools of liberation, justice, and equality, or tools of oppression, injustice, inequality, and hypocrisy. The power wielded by lawyers to make and remake and organize American society defines their responsibility and accountability for society's new norms, including whether we follow the perpetuation of slavery by another name or we seek liberation. There is a clear recognition of the complicity of law to promote this dominant white patriarchy. We have the tools. We have the capacity. Do we have the will to acknowledge this? The historical and contemporary reality calls on legal educators, lawyers, community members, and leaders who truly believe in a thick and rich rule of law to align the discipline and the practice of law with the commitment to anti-racism. A commitment to teaching and learning about anti-racism provides us one of the best opportunities to resume the unfinished work of the 14th Amendment. This work allows us to truly and authentically develop a structure and a curriculum that centers multiracial, multi-ethnic, multicultural, and feminist inclusivity, to expand our community of learners who will engage in the humanizing process of liberation of the oppressed. Working as a collective in this struggle, we can uncover the path to reasoned democratic discourse about the reality of systemic racism and the solemn duty of the legal academy and the legal profession to pursue systemic equity and justice. This is the raison d'etre for law schools, the legal academy, and the legal profession to engage with anti-racism unapologetically. And yes, I am inspired. Number one, all of you stayed in this room and listened to this. You live streamed and listened to this. But it's the collective will that I know that we can build to answer Derrick Bell's call to engage this struggle together in perpetuity. Thank you.
Okay, start with this. Dean Conway, based on your initial work with the Anti-Racist Institute, can you share some of your team's key findings or methods about how to build resilience for racial identity work, anti-racism work among white law students?
Mm-hmm. That's good. And can I take that question sort of one of two ways and address both? So I want to address it first in this way. Is it hard for white students to hear this? And that's invoking that resilience. It is hard if we are not speaking from the same definitions. So we have to understand terms of art and what those terms mean. And that's the purpose for theorizing, right? And not necessarily taking things personally. So even in the talk, I mentioned individual racism, but I distinguish that from things like exploitative or eliminative racism. That's operating at a systems level. So the resilience is found in the understanding of the terms of art, so that when you know I'm talking about whiteness, and you can understand that even a black person who has proximity to power can be within the sphere of whiteness, right? So I know that because of my study and my theorizing. And to that point, and I know I was asked to do a bibliography, I asked you to read Nell Irvin Painter's The History of White People. It's an extraordinary book that really understands and explains this sphere of whiteness and how people move in and out of it, depending on their positionality to power. And that also helps to explain, at least in part, not excusing it, why those black officers acted the way they did. You see, in and out of the sphere of whiteness, which means proximity to power. So then I'll take it another way, because we lean on and require white people to engage and leverage their power. So they too need to top up the tank, because this dehumanizing work harms you too. So in that positive sense, you need ways to also recover, be part of the collective, be cared for. And many times, and I learned this actually from reading Paulo Freire, Pedagogy of the Oppressed, many times white people are struggling in this movement because many times they feel like they have to take the leadership position, right? And that's not necessarily the case. Rather, you are there to uplift. And so in that role, consistent with collectivism, many hands make light work. And the oppressed are supposed to be there, centered, to be able to expose and deliver on their knowledge and their theorizing about their status and position in society.
Okay. This question is about Black erasure, which is, the questioner says, we don't really talk about that. And the question is, how do we move forward in keeping accurate Black history and culture alive, much less Black existence?
Mm-hmm. Mm-hmm. So, again, we have to teach and learn and embed in the work that we do in the law school. And that also means we have to rethink our pedagogy. Is the case method and the Socratic method really critical pedagogy? I just asked the questions here. Is it really critical pedagogy? Well, when we deliver the routinized recitation of the case, and we say we only want to address the legally significant facts, we have to ask, is that the exercise of critical pedagogy? Because what may be relevant to you may not be as relevant to me, right? So is there another way to do that? And I believe that if I were able to work with you in workshop, after about 90 minutes, I could get you to the humanizing, defining, and then ideation stage to say, what's the best way to deliver that case? Now that's hard work, right? Because guess what? You do probably 3 to 5 cases a day. You mean you want me to have a different teaching and learning method for 3 to 5 different cases? Yes. Let me repeat that into the microphone. Yes. But do you have to be the conveyor, faculty member, staff member? Do you have to be the conveyor of knowledge? Or can you co-create and share that burden? Yes. Look at that, everybody. Yeah, I heard some yeses. Everybody in a cacophonous voice say, yes. Yes. Right? Because look how I did that. I'm a little tired up here, but I need your energy. Right? And look how that worked. And this whole thing right here is probably different than anything you've ever experienced in a talk. And is it okay? Is it working for you? Yes. Say it again, cacophonously. Yes. Yes. So it can be done. And is it hard work? Hell yes. You know how long, well, Jennifer, how long have I been working on this thing? Oh, she is. She's so full of it. D. Burke, how long have I been working on this thing?
Months.
I've been working months on this thing, right? Because it meant that much to me. Why? Because you meant that much to me. And that's what I do in every class. So I taught a women's suffrage and 19th Amendment class. And I'm here to tell you I'm no expert in that. None. But I was like, if we're going to bring the ABA exhibit, of the suffrage movement to Penn State Dickinson Law, somebody has got to learn something about the 19th Amendment. And I have a small faculty, and I love you, faculty. And hey, can you teach 19th Amendment? No, you can't do that. So I said, I guess this one's on me. And I did it, and it hurt, and it was painful. But at the end, when I actually did the things I'm talking with you about and wrote about for months to present to you, it worked. And I learned more from those students than I could have ever taught myself. And then, it didn't stop there. I wrote this article. And like 2 years later, there were 88 pages. And they published it. And it was pretty good, right? I learned something. And it was hard, but it was worth it.
Following up on this idea of co-creation, the question is, how do faculty include students without pushing a burden on students?
I love it, right? Okay, think about this, because that question was asked according to the framework of a zero-sum game. Look, they got it. Did you hear that? Who got it? Raise your hand. Who said, mm-hmm? I'm not going to call on you, I promise. Just raise your hand. It was framed over here somewhere in the context of a zero-sum game. So let me identify that there are other burdens like the Black identity erasure. So we have to say, hey, let's weigh that. Is it, in this context, more important to ask for co-creation so that we do not run the risk of Black woman erasure? I referenced my article, which was Black women's suffrage, but the class was women's suffrage, right? So do we weigh those? Yes. And do we ask, will you engage me in modularity, in theorizing about this? Let's take a couple of days and let's role play this. I was role playing with some of your students today, right, Andrea? I see Andrea. I have my reading glasses on. I know there were others, but I see Andrea. So we were role playing today, right? Right. So in that role playing, I got a sense of what could be held in that vessel and what couldn't be held. And that's how you meter, right? So it's not a zero-sum game.
So today, my alma mater announced the formation of a new school.
Don't send your donation.
And this question, reminds me of that because the person says, I've heard people on the right say, politically on the right, feel excluded from academia. Mm-hmm. And that academic hiring principles favor liberals. What do you have to say about this? Do we need a new school?
So there are 400 plus colleges and universities. There are 200 plus law schools. There are 86% lawyers graduating from those 200 law schools who are white. Okay? Come on. Come on. There are 14% Black people in this country. 5% are in the legal academy, not 5 of the 14%. I mean, out of the population of graduates. 1.2% Black women are partners in law firms in the nation. I'm a dean. I have donors, right? When I go to many donors, those donors are all across the ideological spectrum. There are many more on the conservative spectrum. So we really have to be thoughtful about these questions that we ask and recognize, right? There is spherical complexity and dynamism to these questions. So, are there schools that have more conservative leaning faculties and courses? Guess what? Yes, and here's how I know this. Anybody do government contracts in here? Oh, I see you. Bam. Do you know about the North American Industrial Classification System? I'm not asking you, I'm asking them. I know you know. This is a system of thousands and thousands and thousands of employment and industry designations, right? It is complex. It is not linear, it is dynamic. And so it breaks up different industries into different categories. It looks at how many employees that an industry has. It looks at revenue. I mean, it looks at all these dynamic markers. And then you have to sort of tick through and see how the federal acquisition regulation engages that dynamism. That's this question of conservative engagement in universities. We got to look at units. We got to look at departments. We have to look at industries within those units and departments. We have to look at geography. We have to look at donor bases. So to have this linear impression that, yeah, they're mostly liberal. No. That's not how this works. We have to be much more nuanced, just like the NAICS code, for determining how many people are in that industry, how many people of color are in that industry, how many people are hired in that industry, who are women. We got to look at that, and it is complex. So yeah, I can't get with the straight sort of, oh, everybody's liberal. Yeah.
So could you share with us some of the research areas that are coming out of the Institute?
So the research that we are currently doing is primarily focused on producing the 9 volumes for the series called Building an Anti-Racist Law School, Legal Academy, and Legal Profession. So we have over 130 authors who are writing chapters for this series. And I have a fabulous program manager named Tawanda Hunter Stallworth. And she's the one who's read most of the stuff I haven't. And so the idea is that all of these people who are representing about 60 institutions are writing from both their perspective but also the system's perspective on how to implement anti-racism into different functions of the law school. So I am excited to see what they're going to be producing in terms of anti-racism and philanthropy. So that's a big one that we're writing about. And so I'm writing a chapter for that one too, and I'm writing about engaging I love that question, the otherwise erased donor. So that's kind of the chapter I'm contributing. But there's other chapters in that volume that are writing about how do we change the actual advancement systems that we use in organizations. How do we identify donors? How do we steward and cultivate those donors through the lens of anti-racism? Another volume that's really interesting is the admissions and financial aid volume. I know you'd be interested in that one. So how do we move away from centering LSAT scores and UGPA exclusively in the award of scholarship dollars, right? How do we do that with a lens toward anti-racism, which actually wants to assist us in recalibrating so that we can achieve accessibility and equity in the award of scholarship dollars? So that's really exciting work too.
Following on that line.
Wait, so what?
What'd you say?
I just want to hear the answer to that question.
How do we?
We wrote a chapter already about it. And not only a chapter, we wrote an article. So look up this article. You ready? And actually, you could just Google it. So my colleague, who is Associate Dean of Admissions, her name is the most recognizable name. So her name is Becca Seidman-Krauss, Krauss. So just Google Krauss and Google anti-racism and admissions. It's a great law review article we wrote for Rutgers Race in the Law Review. So the answer is in there. And we were very intentional about writing about it because we did not want to fall victim to non-racism by saying, oh, we wrote this and nobody else can have it. We said we're going to put it out into the public sphere. In essence, we're going to give away the secret sauce so that other schools could follow. We felt that was an act of anti-racism.
Let me follow up the admissions,
Okay.
financial aid. You know, we were talking before you started this evening with Judge Aiken. Welcome, Judge Aiken. And we're talking about, you know, these Supreme Court cases we're anticipating coming down this summer. And how, we don't know exactly what's going to come, but we have a sense of what might be coming. And how do we think about that in terms of admissions, and then what you're talking about just now, our reliance on LSAT and GPA and scholarshiping, and what should we be thinking about as we wait?
So in many ways, I am actually pleased that they have framed the argument so actually narrowly and focused on affirmative action. And you know, Stuart's here, right? Where's Stuart? Stuart can help me with this because he's the actual expert. But the way I am positioning this argument is that this is anti-racism rooted in the Reconstruction Amendment, rooted in the 14th Amendment, not some made up or mythologized color blindness with standards. And so my analysis is one rooted in historical context and geared under anti-oppression. And so if those cases come out, we still gonna do what we do at Dickinson Law, because ours is premised on anti-oppression. And so, you know, we'll get sued. I'm okay with that.
Is your general counsel okay with that?
Just saying. He's a very nice guy.
So changing gears a little bit, I have a question about, as dean, how do you think is the best way to work with and promote student coalitions, particularly those of underrepresented groups?
Yeah. So I want to be very clear. students, I said this in a different context, but students are the raison d'etre. You know, and I meant that when I talked about genealogically. That is why we are all here. That's why we're all here. And let's just be honest about it. So, do I, as dean, often avail myself of all the students? No, and there's a reason. I have a fantastic staff and faculty, and I rely on them to make the connections with the students. And I don't want to interfere with that, and it's really intentional. And I'm actually glad you asked that question, because I've never really articulated this, especially to the students at Dickinson Law. But I don't want to be a distraction to the relationships and the networks that they deserve from our staff and our faculty. I'm a black woman, it'd be easy to ride in on that, right? And say, you know, we are connected by a joint experience. I think it's enough at this point that they know this is the work I'm out here doing. And while I probably get a grade of about 78% and how we implement it, I'm out here doing it. And I have a sense that they recognize that. And so I keep doing this work. I keep having these discussions. I keep building coalition around the 200 plus law schools because I believe in them for coming to our law school. So those are the relationships that I value, and they're relationships from afar. But at the same time, they all have my cell phone number. It's on the bottom of every, we have a automated calendar. And the number's on the bottom of my number's on the bottom of every one of those. And there have been people who've called it. Some needed to, one or two didn't. It's cool. One of your students asked me for my contact information. I gave it to her. You call me anytime. I'm here. And that's what I tell people, I'm here. And like, they'll tell me, nah, Dean, you shouldn't have said that, but they don't need me. They don't. They are doing the work. They don't need me.
So let's say they do need you.
Okay.
Sometimes they do need you, right?
Mm-hmm.
There's sometimes when only you can address the situation.
Mm-hmm.
And so how should students approach you with that advocacy?
Well,
when
for
they're
me,
asking?
they just get on the 808.
So they just call
They
you.
just call me, you know, or they come for dinner. I live 2 blocks from the school. I'm not being facetious. I mean, I literally am accessible. But I hear what you're saying. I know what you're asking me. So
It's on the card.
I know what you're asking me. You know, it's just like what I've been talking about. We really have to have a relationship. It can't be dean-student. And you could probably tell the way I got up here and jazzed myself up. I don't have much of an ego. I really don't. And I don't put a lot of stock into the dean thing, right? All that means is I'm responsible when shit go wrong. That's all it means. That is all it means. So with that posture, you know, I think students can come to me and say, I'm having an issue. And I don't send them elsewhere. Tell me what the issue is. Okay, I got the issue. I think this person over here can help you, because I have told you, like I said, hey, Stuart is the expert in con law. I'll tell you what I don't know. I'll tell you in a heartbeat what I don't know. But if I look at you and I see that you need me to stand with you through that, I'm gonna be right with you. I have walked students to the grocery store. We just had a student who got hit by a car. And I spent the entire day and night with her until her family came. I rubbed her feet so that she could get stimulation from a human touch. That's what we're here for. And that's not a tax. That fills my cup of humanity. I've just told you that, but I haven't told anybody that. And don't anybody on the live stream tell anybody that I did that. Because I don't need that. Because I got just as much from it as I think I gave. We have to trust each other. We have to love each other. We have to do that. That's what I'm here for. That's how I make a connection to students in an affinity group. And I sit with them. Even when I'm like, I don't necessarily agree with what y'all talking about. I sit with them. Because that's what they need. That's what they need. They need to be connected. And just sit with them.
So I think we had one other question, and it kind of puts me in the despair mode.
Okay.
So I want you to lift us up.
Mm-hmm.
No pressure.
No pressure. Last question.
As we finish, and as you were talking there, and I was thinking about love versus hierarchy.
Mm-hmm.
And this question is about what's happening with the revision of the AP African American Studies curriculum, right? And rejecting huge portions of actual Black history, right? And so as we think about it, you said K-12 on the front line coming up, like, you know, how do we resist, rebel, accept the challenge when all of these things are happening around us?
You know what? Like, it's so easy to say, right? Dig deep, be courageous, go out there and do it anyway. But again, I'm thinking critical pedagogy. If those students bring it to the classroom, hey, look, they just brought that. They just brought that. Or, you know, you have a huge, big, beautiful house, and I see that you do your desserts with your community. Somebody bring a book, right? There are all these strategies and workarounds, and the power that we have are in numbers, right? And I don't mean numbers of liberals. I mean numbers of people who recognize that book banning is not the way, right? You can be a conservative and no, book banning ain't the way, right? So let's channel that, and let's channel the power of numbers that we have. And let's look at alternative ways of doing this. There's tons of ways to do that. Until, you know, look, they are moving from rhetoric to legislation, right? So it's time to do the protesting, it's time to do the lawsuits, it's time to do all of that. The abolitionists did that. So we have a blueprint. That's where we are. Anybody read Wretched of the Earth, right? So Frantz Fanon tells us some of us got to be in the streets, while others of us are at the negotiation table. We got to organize. This is the time to do that. So those of us who can be in the street, we need to be in the street. Those of us who can figure out how to strategize the book readings, we need to be doing that strategy. Those of us who can be in the litigation and in the courts, we got to do that. Those of us who have friends who are legislators, I mean, how do you think they did this 14th Amendment thing? Dude, come on over, let's get a beer. That's what they said. You know that's what they said, because that's what you say. Right? Let's go get an ale. Let's have a chit-chat about this, and we'll leave our guns at the door. Right? That's what they did. These were rough and tumble people. And we rough and tumble too. Let's lean into rough and tumble.
And with that, I say thank you, thank you, thank you.